first matter to come before us this morning is State of Ohio versus Kevin Ballou. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve any time for rebuttal and you let me know when you get started, I'm keeping the clock this morning to keep you apprised of the passage of time. We have read the briefs and we are ready to see what you are.
Thank you. Good morning, Your Honors. Once again, my name is Attorney Scott Ballou. I represent the defendant, Kevin Ballou. Members of the panel, I think it's unquestioned the leading case regarding jail time credit concurrently sentenced in criminal matters in the state of Ohio is State versus Fugate. And I hope I'm pronouncing that right, F-U-G-A-T-E, is cited in my brief. And the other cases that are cited in my brief, including important case, State versus Cole, all the other cases in both of my briefs, the first brief and the appellate brief, all cite Fugate and its progeny and all that it stands for. And in that regard, Kevin Ballou, there's no question about it, has served, was sentenced on all 3 charges on the same date. We know that, and that's admitted in the appellant's brief. All 3 sentences ran concurrent in all 3 cases. It's clear that the equal protection described in the cited cases established beyond any doubt that Kevin Ballou was entitled to jail time credit in all 3 cases, because any other result would deprive him of the jail time credit at all. Instead of serving the 6 years he was sentenced to, he'd be serving 7.5 years without that jail time credit. And that's not what the court intended, and that's not what the law indicates pursuant to all of the cases. The logic and precedent of the courts discussed in Way, Cole, Lowell, and Fugate require that unless this honorable court grants Mr. Ballou jail time credit in all 3 matters, he will otherwise be deprived of equal protection of the law.
I have a question. He was, he posted bond in the first 2 cases, correct?
That's correct.
So he had no jail time.
No, he had jail time credit at 17 days on one case, 6 days on another case.
And then he didn't post bond on the 3rd case.
That's correct, $250,000
So
bond.
he has 350 days there.
I'm sorry?
So he has 350 days?
No, I would argue, Your Honor, in my brief that he served 530 days total. And that's what, and even the appellants agree that he served 530 days.
I got mixed up there.
I'm sorry, my argument is those 530 days pursuant to Fugate has to, and because it was sentenced concurrently. Had this case been sentenced consecutively, it'd be a different situation. But Fugate and all the other cases I cited indicate that Mr. Ballou should be given credit 530 days for all 3 cases because they were all ran concurrent and he was sentenced on the same date, awaiting jail in all 3 cases. And to otherwise would deprive him of someone who made bond, the $250,000 bond, and have credit for the 530 days on that case. Because Mr. Ballou could not make bond on the $250,000 case, he sat in jail on all 3 cases awaiting trial. And then after he was sentenced concurrently on all 3 cases, and at the same time, he should be given credit 530 days for all 3 cases. And that's what Fugate dictates, that's what Cole dictates. And for some reason, the court, and I really believe that the court's intention was to, in fact, sentence him to 530 days on all 3 cases. But through oversight or some inadvertence, the court only sentenced him to 530 days credit for the 1 case that he couldn't make bond on. That's incorrect, though. The law states in Ohio, as well as the administrative code and the statutes that I've cited in my brief, 14CA010675 and the administrative code all dictate, and congruence with Fugate and State versus Cole, that if someone is sentenced to concurrent sentences on the same date, regardless of whether those crimes were committed on other cases and other crimes, if they're sentenced concurrently on the same date, then the law, according to Fugate and Cole, dictate unequivocally that the court has to give credit for time served on all cases. They can't pick and choose which case to apply the 530 days to and the 17 days to. They all go together, according to the case law.
Excuse me.
Sure,
I'm
sorry.
looking at the language of 2967 191 that deals with credit for time served. And it says, and actually I'm quoting this from page 8 of your brief.
I'm sorry, page what?
8.
Thank you.
The very top of page 8.
Certainly.
That says the Department of Rehabilitation and Correction shall reduce the stated prison term of a prisoner by the total number of days that the prisoner was confined for any reason arising out of the offense for which the prisoner was convicted and sentenced, including confinement in lieu of bail while awaiting trial. Where you have 3 separate offenses and the individual, such as in this case, did not post bond on one, why should we not read this as saying that it would apply to the arising out of the offense for which the prisoner was convicted and sentenced, being the one where the 530 days where the credit was given?
That's
Why do you
because,
read that language out of the statute?
well, that is because the courts went on to say that in Fugit, the courts do not have the discretion to select only one term from those that have run concurrently against which apply jail time credit. And RC 2967-191 requires that jail time credit must be applied to all prison terms imposed for charges on which the offender has been held. If courts were permitted to apply jail time credit to only one of the concurrent terms, the practical result would be, as in this case, to deny credit for the time that the offender was confined while being held on pending charges.
Well, except that there were some differences in the posture of the case that you're citing of Fugit.
Fugit?
Yes.
Actually, the facts are congruent. Now, that individual was giving he was charged with burglary and then he RSP. And then he was only given credit for 143 days and not credit for the full time that he should have been given credit for. And my analysis is in the brief so that it was reversed and remanded so that the trial court would give credit for time served on both cases. The court couldn't choose which case to give the time on. The Supreme Court indicated that he had to be given credit for time served on both charges. Otherwise, it would negate the time for someone who was on bond that got the same credit for. So that would be a violation of equal protection of the laws. And my analysis is contained in my first brief. I don't think it's appropriate at this juncture to read the entire analysis, but I think if the court reviewed that, it would find that the trial court did not have a choice, according to the Supreme Court and State versus Smiley, State versus Hargrove, and State versus Cole, cited on page 10 of my brief, that those cases the court cannot pick and choose which time to apply to which case. As long as it's sent concurrent, all cases are concurrent, those days have to apply to all cases. Ergo, Mr. Ballou's case Kevin Ballou should be awarded 530 days on all 3 of his cases because he served time in jail awaiting trial on all 3 matters, and clearly indicated in the trial court's docket. This correction of jail time will prevent Kevin Ballou from serving more jail time than a similarly situated wealthy defendant under the facts. This would satisfy the equal protection of the laws in the state of Ohio. Ohio law clearly dictates that when a concurrent prison terms are imposed, trial courts do not have the discretion to select only one term to apply in which to apply the jail time credit, but must provide credit in all cases concurrently sentenced. So for that reason, Mr. Ballou should be awarded jail time credit for 530 days in all cases, and I respectfully request that the court remand this case for sentencing properly according to State versus Fugit and State versus Cole. And once again, I believe that the trial court's effort running the case is concurrent, and it ultimately believed that the 530 days were to apply to all 3 cases. And I think that even after I filed a motion for reconsideration of the sentencing based upon that, and the court's intent to consider 530 days on all 3 cases, somehow that was through oversight, that I have to believe, because of the dictation of State versus Fugit and State versus Cole and the other case that I cited, that it was an oversight that the court did not apply the 530 days to all 3 cases because they were concurrent. And frankly, Your Honors, I think that's what the court dictates, and respectfully, I would request that this court consider my cases, consider the law, and as a result thereof, remand this case to proper sentencing pursuant to State versus Fugit, State versus Cole, and all the cases that I cited in my brief. And I respectfully ask for 5 minutes of rebuttal.
You have just that remaining, so. good luck.
Thank you, Your Honors.
May it please the court, my name is Natasha Guerreri, and I represent the county of the state of Ohio in this matter. The state would contend that actually Fugate is the distinguishable facts of that case from this instant matter. In Fugate, the trial court did issue a concurrent sentence on a community control violation, as well as a case that involved burglary and theft. In that matter, the defendant actually was in fact incarcerated on both, or in jail on both of those 2 separate cases prior to sentencing. And the trial court, instead of applying jail time credit to both cases, actually only determined that it would provide jail time credit solely to the community control violation case and not the burglary and theft case. And the Ohio Supreme Court deemed that in not providing the defendant in that matter with jail time credit on both cases, because he was in fact incarcerated on both cases prior to sentencing, that that was in fact a violation of his equal protection rights. Here the facts were somewhat distinguishable in that Mr. Ballou had 3 separate cases, 2 of which he was out on bond. He did post bond on those 2 cases. The 3rd he did not, and therefore was incarcerated during the pendency of that time. So he was not actually incarcerated on all 3 cases prior to sentencing, prior to entering his plea. The trial court here did in fact go back and determine on each separate cases how many days he was incarcerated on each individual case and provided him the jail time credit accordingly, as is required by not only statute but the case law, that the court only provide time for which the defendant was being held.
So in the first 2 cases, the defendant posted bond immediately.
It posted bond within...
Whenever the court...
Correct.
Said.
Pretty quickly thereafter, yes, Your Honor. I believe in the first case he received a total of 17 days, some at the beginning of the case, some at the end, and the second case was somewhat similar, but he only received 6. So the record in this case indicates that the trial court did in fact follow statute as well as case law in providing Mr. Ballou with the amount of jail time credit that he did, only limiting the 530 days to the case upon which he was actually incarcerated for that time period. Therefore, the state would argue that the trial court did not violate Mr. Ballou's equal protection rights because it provided him with what was required under law, what he was actually entitled to under each of those cases. And therefore, the state would request that this honorable court uphold the finding with regard to the jail time credit in each individual case and uphold the decision of the trial court in this matter. The trial court, if the court has no further questions, thank you.
Thank you. I respectfully disagree with counsel's arguments. I think that's an absolute misreading and misinterpretation of the cases she cited. They do not apply. All the cases she cited in her brief don't apply, particularly State versus Brooks. But I believe that there's a mischaracterization of what they even cite in the brief, as well as a mischaracterization of the statutes and the administrative code. If the court takes it, and I'm sure the court will thoroughly analyze all the cases in the briefs, but having said that, the cases do not apply because the relevancy of the 3 cases, the times and the charges do not matter. What matters is the concurrent sentence that he was given on all 3 cases. What matters is that he was waiting in jail, incarcerated in all 3 cases.
Well, how do you, I hear you say that in your argument in your brief, but you are not disputing the fact, are you, that Mr. Ballou had posted bond on the first 2 cases?
Oh, that's correct. 17 days on one case, 16 days on the other.
And he was given credit for that.
Correct. Oh, there's no question.
He was in jail on those counts.
That's correct.
How was he in jail on those counts if he had posted bond?
I beg your pardon. He was out of jail and he posted bond. And the timeline is such that on 9/12/12 he did 17 days May bond. On October 12/12 he did 6 days May bond. On December 12th he made on the large case CR00675 he could not make the $250,000 bond and therefore served 530 days. Now what the law states, Your Honor, is that regardless whether he made bond or not on those, he sat in jail for 530 days on 1 case, and therefore, Your Honor, all those days have to be applied to the other 2 cases because, pursuant to Frigate and Cole, he was given a sentence concurrently.
But
had it been consecutive sentence, we wouldn't be here.
And Fugate, I understand your argument that what is controlling is the fact that his sentence is concurrent rather than consecutive.
Correct.
I understand that. However, in Fugate, he was being held on both of those cases.
He had community control service on him. He was released.
But he was not released on that. He had a holder on that, as well as the bond that he could not post on the theft, RSP, the felony case. So that is, in my mind, an important distinction between that case that you're relying on and our case.
I would respectfully argue, Your Honor, that there's a that Frigate is right on line with Kevin Ballou's case.
Well, how can it be if Fugate didn't involve an individual who could not post bond on 1 case, was being held on 1 case, but for all intents and purposes had been released on the other?
I believe that Frigate and State v. Cole holding is that regardless, those issues are irrelevant, frankly, Your Honor, respectfully, because the important point is when you're in jail awaiting trial on more than 1 case, 2 or 3 cases, then that time while you're waiting in jail has to be applied. The courts don't have a choice, according to the law, to pick and choose which 530 days they apply to, the big case or these other cases. They have to apply, Your Honor, to all 3 cases. The trial court did not do that. They applied 530 days to 1 case and 17 days and 6 days for another case. The law does not indicate that. It's contrary to Ohio law in the cases that I cited, Your Honor, which indicates that unequivocally Mr. Ballou 530 days should apply as long as it's a concurrent sentence to all 3 cases. And he should be given credit for 530 days on all 3 cases, Your Honors. And that's what the law dictates. And I would respectfully request that this honorable court remand this matter to the trial court to sentence Mr. Ballou for 530 days pursuant to Frigate, State v. Cole, and all the cases that I've cited in my brief. Thank you very much for your time, Your Honors.
Both 3 presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website.
Thank you.